Hello, and welcome to another edition of iDS Talks. My name is Hunter McMahon, and I'm the COO at iDS, and I'm joined here today by Lori Armstrong Halber of Fox Rothschild. We're going to have a great conversation about how the world of labor has transformed from binders to hard drives. But before we get started, Lori, you want to give a quick introduction to yourself?
Yeah, thank you, Hunter. Thanks for having me today. I am a 27-year, I think, labor and employment lawyer, which means I spend some of my time doing employment law type issues, and I spend half my time doing traditional labor, which is a little unusual. Usually us folks pick one or the other. But I think today we're going to be spending our time in the labor space. In my free time, I corrupt young legal minds at Temple Law School.
Do you start your course by saying you should drop out now?
I don't actually, because funny you say that. I remember wanting to go to law school and talking to various lawyers. I was encouraged to go speak to partners in different firms, and almost all of them were miserable. And I thought, I want to talk to somebody who likes this. And I did. And the people that like it, I mean, I love what I do. And most of the people that I know that are in this space really like what we do. It's very relevant. It's front page stuff. And it's interesting. But I don't try to discourage them, but I do warn them that they ought to know what they're getting into.
Absolutely. I remember when I was at law school and working for a firm as a clerk in IT at the time, and the partner walked in and said, "Hey, there's this new thing called electronic discovery. I think you might like it. You know, it blends the world of technology and legal." And lo and behold, here we are today. So let's talk about that. Let's get into the topic at hand. When we first met, you were actually telling me how you used to be able to walk in with a 3-ring binder. A Redwell was a big case.
Yeah, I mean, and I think specifically in the context of labor law, it's always been it's based on a statute that was passed in the 30s, right? And it has been sort of this secret society world where labor practitioners have their sort of own rules, and it's governed by the National Labor Relations Board. And there are all sorts of committees to help interpret the rules. And we have our own treatises, the Developing Labor Law and how to take a case before the NLRB and things like that. And it had traditionally been a very sort of old school area of the practice of law. And one of the things that I think most folks don't realize is the way you handle an NLRB proceeding is really different than, kind of what we see on Law and Order or even a regular litigator, right? In regular world, right? There is discovery, and you have an opportunity before you go before a fact finder to exchange information, documents, to take depositions. So everybody sort of knows what's going to happen. And those, magic movie moments, the aha, smoking gun things that happen on TV, they don't actually happen in regular litigation.
Right.
It's a little different in labor world. You don't have that pre-discovery opportunity. The parties sort of send each other requests, and you show up on the date of hearing with a box with binders. And the ALJ will say, exchange your information. Do you all want a half an hour? If you're lucky, a couple hours to look through what the other party has given you. And that's the way it's traditionally been.
That's fascinating, because I was talking to my daughter who's 12 about searching for something. You don't have that opportunity in boxes, if you will. You're flipping through pages. You're not running mass searches. You're not using analytics. You're not using any of your tool set that we are accustomed to in discovery and looking for the needles in the haystack. You're in the fight in the moment looking through documents, but it's changed, or it's changing.
Yeah, I think you were able to join us last year at our midwinter meeting, and you probably heard some discussion about this.
There was quite a bit of discussion, more like side comments about what was going on, but sure.
Yeah. So there is a tension between sort of those that recognize that labor law has to catch up with the rest of the world, and the lack of, I guess, knowledge and resources, familiarity with e-discovery in particular, that is really creating hurdles. I think you heard even members of the board and the general counsel's office saying, it's really incumbent upon us and our folks that work for us to be knowledgeable about these things. And yet we are seeing all sorts of tension where, they've requested electronic information and then it's produced, and then the board doesn't like the format in which it's produced. And you're seeing, arguments before the judges about the documents themselves. And that's all new to labor world.
Well, and I think an important distinction between the labor world and what we'll kind of refer to, I think you called it the normal world or the regular world in litigation, it's the timeline you're under. You're not searching for something and you've got months to deal with it. You've got days or weeks, right?
Yeah. I mean, not a lot of time. Usually you'll get an information request or subpoena. And again, the intent of the board is to sort of fast track a lot of these issues. The policy behind that is that workers should have the right to make decisions about whether they want to be unionized as quickly as possible. The union side, well, I'm trying to be objective here. The union side would argue that employers continually try to obstruct that and do it with various, they would say, nefarious means. And the management would say, well, while we recognize that we have a more immediate relationship with the workers, you have information that has traditionally not been available to employers. And I'll mention the Starbucks cases because they're all over the news, but there have been several fights about discovery. If you Google it, you can look up where judges in different jurisdictions have said, the workers or the union or whomever really do need to produce some of this information. All of this is new, or at least non-traditional. If it's happened in the past, it's been very rare.
Well, and I think that's an important distinction, though. And we often will find, we used to be data poor where, it was a few documents. You talked about Redwells in boxes or binders in boxes. Everybody has information now. So all parties have access to some information, but there's such a volume that we're dealing with and a complexity of the data that we're dealing with today that it is not, hey, print the 5 emails so that I can put them in my binder. We're dealing with a lot of data. We'll just leave it at that. A lot of data to kind of sift through and understand what is going on in a very compressed timeline. And then you're fraught with, but we don't like the format we asked for.
Yeah. I mean, look, there's a case, again, it's a Starbucks case out of Vernon, Connecticut. And as I said, normally there's no pre-hearing discovery in a labor dispute hearing, but the board had subpoenaed Starbucks. I guess there's a document called the Petition Store Playbook. I'm not revealing any secrets, by the way. This is, if you Google, you can find articles on this, for a hearing that was upcoming. And Starbucks had responded to the petition, with a petition to ask that the subpoena be revoked, noting that such a playbook document did not exist by that name, and they would have to produce store managers to testify to that point rather than a records custodian. There's a bunch of normal discovery dispute type stuff. Well, the ALJ denied the request and ruled that Starbucks needed to produce the playbook at issue or have a records custodian testify as to the search for the documents, and ruled, this is the key point, I think, for our purpose, that if Starbucks produced its documents in TIFF plus format, it needed to do so at least 4 days before the hearing, because the board said its relativity vendor needed 2 or 3 days to process the data. Well, that's not how our rules normally work. So
you walk in with the box. You all go into the other room and say, "Okay, what do I have?" Now you're getting. Now they're
asking for what we would consider to be pre-hearing discovery.
Yeah.
Well, a 3-member panel affirmed that ALJ's decision, finding that the ALJ has broad discretion to rule upon petitions to revoke subpoenas and regulate the hearing. And in their opinion, that panel, and I'm quoting, conclude that the judge did not abuse her discretion in requiring that the documents produced in TIFF plus format be produced a reasonable number of business days heretofore before the hearing resumption date. Starbucks argued, as I said, that the production of such documents in advance of the hearing amounted to impermissible pre-hearing discovery. And the panel rejected that argument because the documents produced in TIFF plus format, which they requested, needed to be made available in advance for the third-party vendor to be able to process the information in a usable format. Now, I understand. I mean, there is a practical issue here. That's probably true, right? You can't really walk in with e-discovery.
Yep.
Like, oh, here's my laptop. You got a half an hour to search. I mean, I guess you could, but it seems like it would be cumbersome.
We're talking viable, but not realistic.
So, I mean, this is more of a labor policy argument than probably an e-discovery issue, but I will get on my soapbox a little bit. I understand that the NLRA and the NLRB come from the viewpoint that the employer has an inherently coercive relationship with employees because they have the direct relationship, because they pay the employees. The employees are subject to generally whatever the employer dictates in terms of terms and conditions of employment, and that the purpose of the act and the purpose of the board is to put protections into place to sort of equalize that playing field, if you will, so that employees can have an uncoerced opportunity to decide whether or not they want to be unionized. I get that. But the rules are really becoming weighted the other way. I don't really have a problem. You want to allow pre-hearing discovery, then change the rules and allow it for both sides.
But this is almost the maturity that the e-discovery market has gone in, dating back to, 2000-ish, and then 2000, some of the early amendments. We need to change the rules of the game so that they're fair and known, not coming into something with which way is this going to fall?
Yeah, look, and the board is, I don't think this is any surprise. I mean, President Biden, when he was elected, said he wanted to make this the most pro-union administration in history. And all of the steps that his administration has taken, and the board and the general counsel, very clearly are moving in that direction. But at some point, like, it can't be a rogue agency with entirely unfair rules and procedures.
But isn't that the problem right now, though, that the rules have not caught up to the times? And so you really don't know what rules you're playing by. And so you're playing by the request and the seat of your pants at some level, hoping for a reasonable outcome in rulings, instead of saying, okay, here are the rules. I know how to comply with the rules. I know what the rules are, so I can strategize for my client, which is where your expertise comes in, not get, all right, well, we'll see how this one falls.
Yeah. I mean, it's interesting to me, I guess, as you've said, this is probably just maybe 20 years behind where, if we're talking about workplace law, where employment litigation was,
right,
or any sort of litigation in general, in terms of discovery and production and e-discovery issues, the NLRB proceedings are just decades behind. And so it's creating a bit of a mess.
Well, because, technology waits for the law, right? Said nobody in the practice of law ever. But the interesting thing here is that we've got to get the rules caught up. But, I think we'll dangle the carrot of, don't worry, AI is going to solve everything, right?
Yeah. Well, apparently I'm going to be out of a job, but maybe I'll be retired by then. So who knows?
No, you're going to be inspiring legal minds all over the country instead of just at one law school. But I think it's important that technology is at some level part of the problem, right? We're creating more records than we ever have before. We're having to get through those records. There is a way to get through those records by leveraging technology, but it is not the way that the rules are built to facilitate. So the rules probably need some guidance, updates, or commentary so that everybody can play by them. But the magic button of AI is not going to solve this problem. This is not hey, we can get all of our answers through generative AI and we'll all be better in 3 months' time. This is a kind of a core fundamental problem that expectations need to be level set. Rules need to be updated so that we can all play in the same sandbox.
Yeah. And, to your point, the way unions organize, the types of data or information that would be relevant to these proceedings has evolved.
Right.
Particularly during COVID. And I would suggest that unions were better at it, better at using social media, using electronic communication and other similar opportunities to organize workers. And prior to maybe the last 5 years, organizing was done the old cardboard box way, right? Somebody would go in and talk to workers and hand out literal 3x5 cards and say, if you're interested, fill out your name. And so when you were going to a hearing and you were having a dispute about what happened, the documents that you would need were probably paper documents, but it's not like that anymore. And so the most relevant information you're going to have is going to be in electronic format, which I think puts a sense of urgency to fixing this situation.
But our worlds have evolved. Our day-to-day worlds have evolved. I mean, I was trying to explain to my daughter what a beeper was or a pager was, and she was just.
Well, I had one of those.
She was not having it. She goes, "I don't understand. You couldn't type on it and send, group text messages." But even the supercomputers that we carry around in our pocket are vastly different than what it was 20 years ago, 30 years ago, or let alone back to, the 3x5 cards probably. And I think that the intentions of everything are well and good, but we need to update it with the electronic times that we live so that everybody can have an equal seat at the table and actually understand how it's going to go. And then let's move forward and get to the root of the purposes of the hearings and the investigations and the questions being asked.
Yeah, absolutely.
Awesome. Well, Lori, I really appreciate it. And I want to thank you for joining us today and our listeners. If you would like to learn more about iDS or subscribe, you can visit idsinc.com or wherever you normally get your podcasts. Thanks again for joining us, and I'm sure we'll continue this conversation.
Thanks so much, Hunter.